Tonight we have an agenda, and it's as follows. Number 2 will be the purpose of the meeting. We'll have some speaker notes. It's more or less a recap of what we discussed for the last 2 weeks. Number 3 on the agenda is FRANKLYN GERTLER proposed settlement agreement recap. 4 will be sustaining the claims and compensation. David Babino, video, and Clifford Lawrence, the Stitcher radio. Then we'll have questions. After the questions, we'll take a break. After the break, we'll have a recap, advice regarding the financial aspect, Jack Jameson, he will. Then we'll have recap, exercising the right to vote, Michelle Poirier, questions, and then I'll have closing remarks. So first of all, I just want to welcome you all here tonight for our third public meeting. I promised the community 3 public meetings. Tonight is more or less a recap of what we discussed in the first 2 meetings. I want to welcome and thank you all for coming to this information meeting on this proposed settlement agreement. I would welcome all the members listening to this meeting on CHRQ and on the web. Last week we had a good number of people listening to the radio and on the website. I'm glad that the message is getting out to them some way, some form. You know, the communication between the team has to go out. That's what we're here for. In the first 2 meetings, we clarified what the settlement agreement is all about and isn't about, and correct the misconceptions about it. We explained the key points of the agreement being submitted for ratification. We explained the revised and simplified ratification question, which will be answered yes or no. It's on your first ballot. You accept the agreement in principle, yes or no. We explained the options A, B, and C for the handling of the settlement funds as set out on consultative second ballot to provide direction on the handling of settlement funds. That one is the second ballot, where it's A, B, and C. A is distribute to all the members. That goes to a trust. B is you can take a part of the money, put some in trust for the future. And C, you put it all in trust, and the people will decide how that money will be spent. We have received and answered a lot of questions from the members and have given their thoughts on the proposed settlement agreement. I really appreciate and thank those who took time to attend, and especially those who shared their views and those who asked questions. I and our professional staff have worked diligently to provide the community with information about the proposed settlement agreement and the options for handling the settlement funds. We will continue to do so right up until voting day. So if you have any questions after today, you can contact one of us at the band office, myself, or Jeff. Jeff is there most of the time. Present with me tonight are from my right, Cliff Lawrence, Michelle Poirier, FRANKLYN GERTLER, Jeff Bass, John Alexander, and Jack Jameson. For those that are just new, Jack Jameson works for EE Wealth. Cliff Lawrence is the appraisal. Michelle Poirier is the chief the voting person. FRANKLYN GERTLER is our legal advisor. Jeff Bass works for the negotiating team. And John Alexander is director of finance for LMU. We welcome your questions and we will be happy to provide answers. We have made a lot of information available. We have held public meetings as a community. We have asked good questions and have received answers. We have debated the options. Now I hope every member exercises their right to vote. Both ballots on these matters of great importance for listeners. You know, you need to go out and vote. Can't stress that enough because of the fact that you asked the team to negotiate this for the last 17 years. This file has been ongoing for over 200 years, so let's vote on this and let's move forward. On December 13th, like I just said, the community must decide whether or not to ratify the proposed settlement agreement. And through the second consultative ballot, give direction on handling of the settlement funds. Your answer on the second ballot that will tell Chief and Council how you want to spend the funds. Do you want to put it in trust? Do you want to share it amongst each other? It's your choice. It's not our choice. I am sure that we all have a good meeting. and we will all make an effort not to finish too late. Now I'll go over tonight's agenda. I already went over tonight's agenda, so next on the agenda will be FRANKLYN GERTLER to recap the proposed settlement agreement.
So it's just a recap. We've already presented most of this material. And so I wanted to just give a very quick background for those who haven't heard some of this, and then go into the most important points in the settlement agreement. So the first thing is just to talk a bit about the background of these claims. The chief said it goes back 200 years. So we started with history actually before 1787, back in the 1760s. Basically what's happened here, and most of you will know this, but it's helpful to remember, is that after the American Revolution, the Loyalists were brought to settle, and we followed even the ship's manifests of the same family names, the Mans and the Bastides, coming from Quebec City and settling here. And over all those years, there's been protests from Listuguj about the loss of lands and loss of resources. Those protests were especially regarding the loss of regarding land dealings and the loss of resources in and around Listuguj fishing and fishing stations, forestry, cutting wood, farming. You go back in the record, you find places where your ancestors were saying were begging for firewood because they had no fuel, and so forth. So the basic theme, or what we were talking about, was the failure of the Crown to live up to its obligations to protect Mi'gmaq lands, as promised by the Royal Proclamation and the Peace and Friendship Treaties, of course, in which there was no land cession. And the Crown asserted its sovereignty and promised to protect Listuguj's lands. And we have the record going right back to the dealings with Chief Joseph Claude in those 1780s. So over those years, there's been a mountain of work done by the elders, by the leaders, the various Sagamon over the years. And there have been petitions and surveys and delegations, research, claims with the Gaspé Land Commission, as many of you will know, trips to Ottawa and to London, England. But there was never any litigation, and there was never any negotiations or satisfaction. Never any negotiations, never any satisfaction. But in the 1980s, the 1990s, there were specific claims. There's specific claims research about Bastide, about Man Fraser, which included, of course, the disputed acreage, the strange angle, mission, the 132, the bridge approach, and also, for example, the River Islands. The River Islands are not in this set of claims because this set of claims was brought to court in reaction to changes to the Civil Code that would have shortened the limitations period of the Civil Code of Quebec. And the River Islands are in the New Brunswick side. So that's one of the outstanding pieces of work that needs to be done. I'm always pleased to learn that people sound like they're making good use of those River Islands. So as I said, some people ask, well, why do we have these 5 claims? Why did this litigation get taken? There was research going on over many years about the specific claims, but in 1994, Quebec changed its civil code. The Supreme Court has said, not for Aboriginal land rights or title and treaty rights, but for claims of this kind, specific claims regarding land dealings, breach of fiduciary duties, the provincial civil code limitations periods do apply. So the Quebec changed the limitation period from 30 to 10 years, and I won't go into all the detail of how it would be calculated, but there was an argument, a strong argument, that if the claims were not already out of time, they would have been out of time on the 1st of January 2004. In 2003, in December 2003, Listuguj Chief and Counsel asked us to take action in the federal court for breach of fiduciary duty and compensation for loss of use of lands regarding those 5 claims. And of course, that's Man Fraser, Bastide, Mission, Interprovincial Highway, and 132. And at that time, we made an estimate that those would be, the total compensation would be $100 million. That was simply an estimate. You have to put something in when you file that had not yet been researched or appraised. And I want to make very clear, and the statement of claims specifically says this, it is not a case about Aboriginal rights or title. It is under reserve of Aboriginal rights and title in your treaty rights. What happened then was the specific claims, some of you will be aware, specific claims have been a terribly slow and dysfunctional process. There was a huge backlog. It may have improved somewhat now with the specific claims tribunal, but we refused. Listuguj, in typical fashion, said, well, we're not just going to put our case on hold and take a number of the specific claims process. We want to negotiate our own deal, and so that started in 2003, and it took until 2008 for the federal government to finally name a negotiator and create an envelope, and they made an opening offer, as some of you will be aware, in October 2008 of $21 million. And at that time also the $21 million plus the addition of the acquisition by Canada of the Bastille lands and their addition to reserve. So Canada, Listuguj rejected Canada's offer, and we proceeded then to just get into a numbers game of saying, well, how much, kind of a crapshoot. We actually went and did our due diligence with historical documents, with appraisers, with economic historians on what a proper measure of damages would be to compensate for loss of use and the current value of the lands plus interest and so forth. So as I mentioned, part of the deal was to purchase for the federal government to acquire the Bastille lands. There was no money put into that by Listuguj, and they were added to reserve. That happened in 2009, and they were added to reserve in 2012. And then in June 2012, so this was after really a year of very active negotiations, a couple of years of us doing our homework, and we had, among other things, the 26 volumes, count them, 26 binders of historical documents that we had obtained from Canada as the background to the claim. So in June 2012, we reached an agreement at the table, not binding on any of you, but an agreement at the table on a settlement compensation amount of $64.5 million, and plus the global settlement, plus the addition of the Bastille lands. And all of that was, of course, subject to ratification. And that wasn't the end of the story. That was just the compensation, which was a big job. But then there was another year and year and a bit from June 2012 till September, October 2013 of negotiation of the actual terms of the agreement, because obviously it's a two-sided thing, and Canada was looking to get certain things in return about what would happen in the future and whether these claims could come back. And we'll get to that in a minute. So there was a detailed negotiation process, and then, as you know, there was almost a ratification process last spring. That was put on hold. We did a little more negotiation this fall, most notably to change the ratification question. And we, in the end with an agreement that it's pretty clear is groundbreaking in a number of respects and very favorable compared to deals that have been signed across Canada. And of course, the important point is, what I'm referring to is its protection of Aboriginal rights and treaty rights and Aboriginal title. So I just want to do, this is very, very briefly rough, but you've all got in your packages, you all have the settlement agreement itself. You'll also have a plain language summary of the settlement agreement, as well as other documents such as the explanation of the vote, the plain language summary of the ratification process, the frequently answered questions, asked questions, and so forth. But here, there are just really 5 key points to know about the settlement agreement. The first one is that this is an out-of-court settlement of the 5 claims, and it's limited in scope, this is number 2, to settling those 5 claims. All other rights and claims, whether these specific claims, Aboriginal rights and title, treaty rights, are unaffected. Here, of course, as I said, this is a negotiated settlement agreement. gone to court, it would have been all or nothing. It could very well have been nothing. It could have been another 20 years and a lot of money spent. You come back with less compensation. Canada obviously pays compensation of $64.5 million. And that is, we've got some detailed clauses which provide that they can't play a kind of a shell game and give you a second time give you money that you're already owed. You want to make sure that it's new money and doesn't prejudice other programs and rights of individuals in the community to other kinds of benefits. And of course, the acquisition and the addition to reserve ATR. On Listuguj's side, the agreement is never to make these particular claims again, never to claim against Canada a second time for the breach of fiduciary duty regarding these various parcels. We also have to agree not to go back against Canada for any complaint about how the money is used or spent or in the future. They want there to be kind of a clean break on this issue. And there have been various questions about what we don't have to agree to. And of course, one of the most important ones that people have asked about is, well, what happens to the 132 and what happens to the bridge approach? And the general answer to that is that the agreement specifically preserves your right to go against Quebec with respect to the 132 individual bridge and to seek compensation or periodic payment or rent, I guess you could say, for those lands. As those who are here know, the situation was that the 132 we regard it as, Listuguj regards it as being part of the reserve. Canada says it's not, but one way or another, the status quo has not changed. What is done with the agreement is that there's compensation for the loss of use of the lands of the 132 over the years since the beginning, and the right of Listuguj to continue to seek compensation or periodic payment from Quebec remains. And as the chief said the other night, we're going to go on. Listuguj is going to go on patrolling, policing that area, and that will not change. For the bridge approach, it's very clear. Canada is very clear on this. There's no dispute. It is part of the reserve and remains part of the reserve. So Quebec is in the position of as a squatter and must seek a permit under the Indian Act, Section 28(2), in order to occupy those lands, and that would involve compensation on periodic pay. So number 4 of the things you need to know, and this is very important because people have asked about this a lot. Well, what are our rights after this agreement? Canada, from the very start, and some of you will have seen some of Canada's correspondence on this, where they asked for a quieting of title clause, which would have said not only can the existing private property owners remain in place, but you must promise not to attempt to exercise your Aboriginal treaty rights and your Aboriginal title in those places. We've got a different kind of solution, because we have very specific direction not to accept a quieting of titles clause. So the clause we have does deal in some way with how those relations will be going forward. And it's called the relations among interest holders. And the basic compromise, if you like, is that the existing rights holders are entitled to the ongoing exercise of their rights. Not new rights, not new mining rights. Just people talk about what if oil and gas is found there. That would be a different matter for the future. But the existing rights holders can remain in place. But Listuguj can also go on exercising Aboriginal treaty rights, including Aboriginal title. And this is the important thing. Rather than the usual clause, which would say we must promise never to try to exercise our rights, never to sue, never to assert those rights. Instead, what this agreement says is that any dispute, so it contemplates the idea that there'll be a dispute in the future. Any dispute will be settled by between Listuguj and the interested party by agreement or through the court. All of this, the obligations of the parties only apply upon ratification by a vote on the ratification question. That is the yes or no question. And in that vote, as Michelle Perrier will explain to you, it's a two-part special majority in which you not only have to get the majority of the votes to have either a winner or a loss, but for the agreement to be passed, it has to get a majority of the votes cast, plus that majority must include at least the number which is equivalent to 25% plus one of all of the eligible voters. So this is not like an ordinary referendum question, it's not like an ordinary election. In this case, you have to get this special majority because of the long-term thought, electing the chief of council for 2 years. It has long-term implications, and therefore there's a more stringent, more difficult vote to pass or test or threshold.
Good evening. My name is Clifford Lawrence. I'm a real estate appraiser with Pistesher Appraisals based in St. John, New Brunswick. The video you just saw is on your website. It was produced by us at the request of the Listuguj Mi'gmaq Government to explain our involvement in the process. If you look, you'll find other videos. There's one by Daniel Babineau, who was an appraiser, Daniel Doucette, I'm sorry, who was an appraiser and appraiser advisor to the LNG. And in David Babineau's video, he mentioned Carl Beal, an economist based in Saskatchewan, who provided invaluable advice and direction, particularly with the loss of use aspects of the valuation. Our role through this process has been to assist both the LNG and Canada to understand the impact that they're playing in monetary terms. Some of the things that we've had to consider are the areas involved, the reach dates, the historic land values, the highest and best use of land through the various periods in time. David mentioned one example, the fishery. The Listuguj, as you know better than I, is famed for that fishery. There were other slides that you noticed through David's presentation. The river, at certain times, you could walk across it for the logs, and we all know where those came from. They came from these lands. So when David mentions the highest and best use analysis, what he's talking about is what uses were made of these lands. It's key that be identified, because in our profession, the use of the land is fundamental to the income that it can earn. One of the questions that was pivotal to the negotiations was the area of the land involved. And there are two slides here. The gray areas are lands that in Canada's $21 million offer in 2008 that didn't take into account. For those of you who can interpret these maps, you'll see a gray area in the Bastide property. Canada was claiming that was not a reach by Canada, that was a deed by Quebec. The triangular portion is referred to in historical documents as the so-called disputed angle of the Fraser lands. Canada was claiming that the addition to the reserve at one point in time was made in compensation for that. But scrutiny of the historical record and consultation with Mr. GERTLER and the records we could find showed that probably wasn't so. That probably wasn't so. At the same time, there were reserves established for other communities. But if you look at the difference between these two slides, you'll see that one shows 6,000 acres and one shows 2,000 acres. Obviously, the claim is dependent upon the land area. The claim is also dependent, of course, on proving breach dates. The further back in time the breach occurred, the larger the claim because of the compounding effect of the rent that ought to have accrued to the community. This one simply shows the two properties, or the two positions, if you will, side by side. As at February the 10th, 2012, at that point in the negotiations, this essentially explained the difference between the compensation offered by Canada and the realistic claim as envisioned by the LNG negotiators.